Good evening. After a marathon 10-day hearing, the Supreme Court has delivered a landmark judgment on same-sex marriage. It has reverted the entire process after hearing from all the parties. It has reverted back to the Legislature and said that the Supreme Court is not in a position to take a decision on this very pertinent social issue, and the AIDEM Interactions is now today taking up this topic, the impact of Supreme Court stand on same-sex marriage. And joining us in this discussion is Thulasi K. She is a Supreme Court lawyer and a regular commentator on socio-legal issues. Interestingly, she has written an article about the same topic in today's media, even before the Supreme Court has started delivering its verdict. Thulasi, welcome to the discussion. And joining us in the panel is Laina Emmanuel. She is the CEO of Brainsight AA and a social and policy issues observer based in Bangalore. She has nearly 20 years experience in healthcare management and policy and consulting. Laina, welcome to the talk show. This is the AIDEM Interactions. We are discussing social issues, the current contemporary social issues. And today's issue, we will start with Thulasi. In your article, which appeared in today's paper, you said that the Special Marriage Act can be used to address this issue with very slight changes. So we'll start with that. What are the changes that can be incorporated to the SMA so that this contentious issue can be dealt with?
Yes, I think you're referring to an article of mine which has appeared a couple of weeks back.
Okay.
Probably not today. But yes, I think, in fact, the language of the SMA, the interesting thing about the SMA, I think, is that it does not really require the Supreme Court to rewrite the law. And this is one of the things that we've argued before the court. It merely requires the court to declare that same-sex couples could also be covered under the Special Marriage Act. In fact, that's all what the petitioners, to some extent, that's all what we were demanding from the court as well. And I think it is only to complicate issues that partly the court and to some extent the government went on to comment on the repercussions that it could have on various other statutes which have the framework of identifying a marriage or conceptualizing a marriage in a man-woman binary form. But I think ultimately the question is, whether a practice or whether a non-recognition, in this particular case, a non-recognition of marriage of same-sex couples is violative of fundamental rights, broadly speaking, of the right to equality, the right to liberty, and the right against discrimination. Then the court first needs to answer that and say either of the two, that either it is discriminatory and it is violative of the constitutional framework or the constitutional rights that have been guaranteed to these couples, or it must say that it is not a violation of these rights. Now, the problematic thing about today's judgment is that it actually says neither and takes a very, very interesting and very strange route of relegating to the legislature, of constituting a committee and giving them certain rights or recognizing certain rights and so on and so forth. So to just answer your question, I think the SMA, because of the fact that it does not say man and woman in the relevant provisions, it only talks about union of two persons. So, there is no need for any reinterpretation or any rewriting as the government was in fact arguing before the court. What we just needed the Supreme Court to do was just to say that SMA covers homosexual couples as well, which the court unfortunately failed to do.
Okay. The Supreme Court bench headed by Chief Justice D.Y. Chandrachud has referred it back, as we have rightly pointed it out, it referred back to the Legislature. So, but the government, the union government, has already taken a stand which goes against the argument that the same-sex marriage has to be legalized. So, Laina, what is your take on this? How do you react to this? Because how far can we expect the legislature to take this forward, this conversation forward?
I must confess that I'm just an ally to this whole cause. And more than that, in terms of the legalities of it, I'm actually here to learn from you, more than anything else. And thank you for the information there. But in general, from the limited reading that I have done and from the conversations that I've had with friends and relatives and even family members who might fall into these categories, is that at the end of the day, the Supreme Court had to just pronounce very simple things, as Thulasi had pointed out, right? And now it has been lobbied off to the legislative. How much and how is it? I think it's a politically fraught subject to bring up. And so when you lobby it to the to a legislative committee, it's obviously going to intersect with a lot of political ramifications, with a lot of politic playing on the ground, which will then murky the whole issue, which I think was not necessary at all in this case. But again, it is one of those things that people have to fight for, and all of us have to fight for it.
Okay. Now, as Thulasi has pointed out, there is an ambiguity in this today's judgment. At one hand, it says that the parliament and the state legislatures have to create the law, enact the law. The court cannot enact the law, it can only interpret the law. At the same time, the Chief Justice of India has said that the relationship of marriage is not static. It has to be a dynamic relation between two people. So how do we deal with this ambiguity? Thulasi, do you have any idea how we can legally take it forward?
Yes, it's the interesting part is that there are, of course, various observations and findings in today's judgment, which will, of course, help, sexual minorities, generally speaking, to sort of further their cause and to have wider participation and awareness in the cause and in the rights of LGBTQ persons. But ultimately, I believe, and I think many of the lawyers would definitely agree with me, that the role of the court, the job of the court, is ultimately to adjudicate. It's not to mediate, and it's definitely not to defer questions of fundamental rights violations to the executive or to the legislature. So, of course, there are certain things which it can and which it must defer to the legislature. Examples of, for example, policy issues, matters of budgetary constraints, which the legislature and the executive alone can maybe determine, which is not in the domain of the court, and which the courts are not experts anyways to make these decisions. But when we talk about interpretation of fundamental rights, when we talk about interpretation of Articles 14, 15, and 21, and when a group of people come before the court and say that my right has been violated, there are only two ways the court can go about it. And to say that it's creation of an institution of marriage by the court is also slightly misleading. It's because it looks like the court has to create something anew. And I disagree with that, because the institution of marriage is already there. It's just that it's an incomplete institution. Incomplete in the sense that it does not afford the protection to certain persons, namely sexual minorities, within the ambit. So various privileges associated with marriage are not extended to a group of people. And this denial is purely and solely based on sexual orientation, which is again a prohibited ground under Article 14, which has been agreed and accepted by the Supreme Court in Navdev Singh Johar judgment in 2018 and henceforth. And it is the same Supreme Court that we hear today, which says that we will record the statement of the Solicitor General that a committee will be constituted, and that I think should sort of shock the conscience of both the persons involved and generally LGBTQ persons overall, and that's been the response as well. And in that way, it's quite disappointing. The takeaway could be definitely that there are some positive observations which are made by the court, which can be sort of furthered and which can be lobbied. But I still think that, considering the stand of the union government in the court, and that's been their consistent stand throughout, of disrupting the institution of marriage and changing the traditional name of marriage and so on and so forth, and to trust that kind of an executive and legislature with this kind of a job, I think, is just misplaced.
But then we are talking about the legality or making same-sex marriage legal, legalizing it. The question that we have in front of us is that even though homosexuality is legal in many countries across the world, only 32 countries across the world has legalized same-sex marriage. And in Asia, I think only Taiwan has allowed same-sex marriage. So, Laina, what could be the stand? What could be the future for India when we are talking about legalizing same-sex marriage? What do you see? What do you see?
I think, like somebody said, right? Like all societies move towards a more liberalized view of a more liberalized view in terms of how relationships are formed, and a more fundamental view in that being able to say that everybody has fundamental rights. So both really, and I do believe that overall, when you have so many countries moving to it, it's certainly a minority. 32 is not a very big number, but I do think that there is increasing awareness across the world for these kind of issues, and which I do believe that India will also move towards it. It's going to be slow, and it's going to take really brave people like the ones who went to Supreme Court and to fight it, and on those little matters that Thulasi talked about, right? There are some observations which you will now take, and then you'll take it back to court and you will fight further. The journey is going to be long, but I do believe that at some point it will come together. It's going to be long and hard, but it should come together. It's at least my hope more than anything else.
You have to be extremely optimistic to think that the course that India is taking right now is we are moving forward in bringing about a social change.
I think optimism is the nature, and like you have to be, otherwise you're going to be falling into despair. So.
Well, Thulasi, during the initial arguments in this case, I think it was sometime in April or May, Justice Chandrachud even suggested that, I quote, incremental changes in issues of societal ramifications are a better course to take, unquote. So he suggested a phased manner, it's gradual change towards legalizing same-sex marriage. How possible is that, or how logical is that? How what is the rationale behind that?
Of course, that's a sensible proposal, but I think that's more sensible if it comes from the legislature, because the court talking about whether the society is ready for this change is I think problematic, because it might make sense for strategic reasons or otherwise political reasons, of course, for the legislature or the government to say that we bring up this measure, we will do it slowly, we will see if the society is ready for it, and these things coming from the government is not a surprise, and governments have often launched these arguments. The same thing they said in the Navte judgment as well, whether society is ready for homosexual couples. But my problem is that the court saying it and the court sort of playing by it is deeply problematic, because that's not really, at least that's not the way I see the role of the Supreme Court. Because the role of the Supreme Court is not to really to care about even popular sentiments. The role is certainly to care about the Constitution and to see whether the legislative actions or the executive actions are in tune with the constitutional framework or not. So in this case, the court only had to consider whether the non-recognition of marriage for one part of the population of the country was violative of that constitutional framework. And without answering that, to talk about the incremental phase of the change, I think is just answering the or identifying the wrong issue at hand.
If you see the rhetoric around the whole thing right now, everybody's talking about how well the judgment was narrated, which is beyond the point of the question that is being answered is just wrong, right? If the question has moved from what it originally needs to be, then how well you articulate your position is not important. And I think that was that's something that I've been seeing across Twitter, across various different media, right?
Like in your article, Thulasi, you mentioned about the changes, because one of the contentions against legalizing same-sex marriage is that the changes made to SMA can impact on other laws like inheritance law, or related thing, all the laws related to the institution of marriage. How true is that argument? How strong is that argument?
There is, of course, an argument which emanates from the ambit of the Hindu Succession Act, for instance, which has been one of the arguments which was launched before the court as well. But of course, the important aspect is that how to play out this recognition if the court was, indeed ended up recognizing or saying that non-recognition violates the constitutional rights of the petitioners. Then, of course, the working out of the formalities as to how it would, actually play out, and how other legislations have to be interpreted in tune with or in the light of this recognition, might be something which the legislature and the executive might be able to do. So that was, of course, an option before the court to say that, and there are, of course, various examples when it comes to, legalizing same-sex marriage. So there are several countries abroad which have devised this mechanism of suspended declaration. So essentially the idea is that you have said that the law as it stands is under-inclusive because it does not include same-sex couples. And then the court goes ahead and says that we have hereby declared that this is unconstitutional. But since if at all there is any void that will be created, or if at all there is any lack of clarity with respect to how it will actually play out and the regulatory aspects, we are going to give 6 months of time to the legislature and the executive to actually lay down the rules as to how same-sex couples will marry. So and this is only just one among the various options that was available for the court, and all of these could be taken recourse to if the court had indeed taken the route that there is a problem here of violation of rights. So I think those are. It's worth recognizing them as problems, but it's also important to acknowledge that there are solutions to get by.
Yeah, Laina, you said you are a fellow traveler of this course. You have been engaging with people who are raising this issue repeatedly. But then during the delivery of the judgment, there is a mention, I think it was by CJI, is that the legislation and not activism is the way to solve issues of this social impact. So activists, as you have rightly said, were very optimistic in the morning when they were expecting to get a favorable judgment from the Supreme Court, Honorable Supreme Court, but then we have seen what it turned out to be. So what could be the next possible ways for the activists in raising this cause?
I think multiple ways, right? And some of them Thulasi has already mentioned. One is just taking some of the observations which are there already in the legal judgments and then using those as grounds to further this cause. The second is, I think there is this whole understanding even amongst the community that yes, optimism is a good thing, but they came in with a sense of realism, right? Like it was not like they expected that everything will go their way. And so there have been thousands of conversations now across dinner tables where people have started acknowledging these issues. And you see this in families as well. Like my own mother would be so aghast, like reading about all this a couple of months ago or a couple of years ago. And now she's just like, hey, okay, I've been seeing this on TV. I've been reading this in the newspaper. And so the conversation has moved. And I think that itself is such a great thing. And the conversation will keep moving. Now, what the Supreme Court was expected to do was to move that conversation really fast forward by like making good judgments in these. But they also took the incremental way, which I am not very sure is a great way for the court, but it is the way it is. And activists will need to have to build on that and to build on the conversation space that has been created right now.
So Tulsi, responding to this judgment, Solicitor General Tushar Mehta has said that this is an important step in jurisprudential development on the question of separating the powers and providing vivid and elegant insights into the working of legislature and judiciary and executive. So should we take it to that level where this judgment, because is it not a collective effort to bring about a change which can impact so many people across different sides? Because the court itself has observed that sexual cure nature, it has been there from time immemorial. It's not a recent urban elite characteristic. Sexual orientation has been discussed long time back. So is it, as you have rightly pointed out in the beginning, compartmentalizing this legal lawmaking to one segment and then interpreting to another, is it not advisable to have a collective effort to bring about a social change, address this issue together and bring about a collective effort, solution to it?
Yes, that's been the argument of the government. But I just think that courts are not institutionally designed to bring social changes, at least not as their primary, duty as adjudicators of constitutional law. Of course, judgments will have an impact on social change and will have progressive impact depending on what kind of judgments and what kind of attitudes the court is taking. But that's almost automatic in a society like ours, where the courts have prominence in public discourse. We see, for example, in the kind of deliberations that we have, the courts play a major role, and what the courts say matters for legitimacy as well. So we see very often politicians justifying certain actions by saying that, oh, the court has said so, or the court has not interfered, therefore there is some validation of the legislative action. But my disappointment stems from the very fact that it was not really a case where where everyone had to work together to sort of get the society accept this idea of same-sex marriage, because that is happening somewhere else, right? That's happening outside the court. For this acceptance, one wouldn't come to the court. For this acceptance, filing petitions in the court is also not the right way. The right way to build that momentum is, of course, outside the court. It is in the streets. It is to have rallies and peaceful protests, for lobbying the government, for lobbying civil society activists, for encouraging this kind of development of this attitude among the people that everyone requires, everyone deserves to have equal rights. But why the court was approached was for a very specific legal and constitutional issue. And that is where, and that is where whenever the court sort of tries to enlarge the issue by saying that, oh, it's a separation of powers, or it's, something that, let's look at the incremental social change, I pause for a moment, because, you need to really cut short and streamline the jurisdiction of the court here, what the court is actually asked to do, and, what it could do from that limited framework. And that's all what would matter, because everything else would be platitudes. Everything else was the court say with regard to, what should be the treatment of society, what should be the treatment of the government towards same-sex couples. All this are to a great extent meaningless without actually enforceable directions. And I think that is the void here that we are feeling very strongly, that it was not a real question of separation of powers. It was an actual question of rights violation.
Okay, Cure Right activist Harish Iyer has already said that it's a war and this will go on. He has treated it, decided to take a very aggressive stand on this following this judgment. Later, what could be the options available for them? Which are the avenues open now that the Supreme Court has clearly put the issue back into the streets? what could be the option?
I feel like you answered your own question in terms of your last question about how does the legislature and the world work together to get this conversation up, right? And in the world, you will have people who take more aggressive stance and you will have people who will take the softer stance of going through culture. I mean, there are so many avenues available. So one is just the increase in media about these kind of topics, and not just like debates that we are doing or conversations that we're doing, but just a very surreptitious way in which same-sex couples are now shown in movies, in OTT, everything, right? Like those culture conversations are happening today. That's one option that is building up as we speak. The second option is the legal options. The third option is discussions like what you are having. I think all of these will fall together. I think the conversations with children, which are happening across the country now, where they're questioning their parents about these kind of conversations, and all of these are avenues, and all of these will be used by people in different ways. The more activist people will talk about it with anger, the more strategic people will try to use it strategically to kind of think of a long-term change. It'll all happen now. And I think it's all thanks to the judgment and the conversation around it.
So that brings us back to Thulasi. What are the legal options available? After this today's judgment, what are the legal options open for activists?
Strictly against this judgment, the only possible avenue is a review, which, of course, I would think has few legal grounds, because unless and until there is an apparent error on the face of record, review petitions do not lie against judgments of the High Court or the Supreme Court. A lot of people are hopeful that we did get a judgment like Navdeep Singh Johar, even after the Supreme Court reversing the Delhi High Court judgment in Nas Foundation. So that, of course, could be, it's not strictly legal in that sense, but it's of course, like, we need to wait and see whether the judicial attitude will turn around, and whether the court will, in fact, in my view, at least rectify the mistake that it has done today.
Because in the end of the day, it boils down to the ensuring the rights of the queer community, who are also citizens of this great nation. So we need to take up this conversation forward and keep working on it. And the conversation, the more we speak about it, the more aware people will be about it, because there is still a lot of confusion about this thing, because the arguments pitched against the legalizing same-sex marriage are mostly based on tradition and all the narratives that are already there. So we need to create the LGBT community, the queer community must create new narratives which can advocate their cause and put a strong cause in front of the public, so that an opinion can be formed. And as Thulasi has noted, we need to change the legal outlook also. So thank you, Laina, for joining us in this AIDEM interaction. And Thulasi, thank you for your legal inputs. That has been very helpful. Thank you all.